Both rise. Appeal. Wynne-Finch and Birss against National Resources Board for Wales.
Yes, good morning.
Not having done one of these for a while, my lord, I'm going to start off with, do we need to give the usual warning to anybody watching that to record or take a screenshot of any of these proceedings by where the live stream would be a criminal offence? I know this is usually done in all the other cases I've had.
Well, I'm bound to say I haven't been giving that warning, but no doubt it's as well to record the fact for anyone who is watching on the live stream to repeat that no record of any kind may be taken or made of the proceedings.
I'm grateful, Lord. I've just had a couple of problems in the background with a couple of cases, so I just thought always.
Yes.
Now, for the record, my lords, I'm Fenner Moran and I appear for the Appended Claimants. If it pleases your lordships, my learned friend Mr. Wynne-Finch at Queen's Counsel and his learned junior Miss Holmes appear for the respondent defendant.
Yes.
A little bit of bookkeeping first. I'm assuming that your lordships have all the bundles, with a core bundle, 3 supplementary bundles, and I think, physically, 3 lever arch files of authorities plus a small supplementary authorities bundle that came down yesterday.
Yes, I have all of that.
Excellent. Next question. Have your lordships read the skeletons as well as the judgment?
Yes.
I almost automatically assumed that, but I thought I'd start with that. Well, in that case...
But not a great deal more, I have to say.
Not a great deal more. I'm not
I mean, in the case of this nature, it's easier to be guided through a lot of the material than to plunge in unaided.
Yes. Now, what I intend to do is, critically speaking, just go through the issues as they appear in my skeleton, and fundamentally in the order they appear on the grounds of appeal. That's tab 1, page 10.1 and 10.2. So in other words, I'll be dealing first of all with the category A reservations. That's the private conveyances reservations, including the word stone. Then I'm going to be dealing with the category D plots. That would be the reservations, what we say reservations, made under the Arustley Enclosure Act 1816. Then, quite quickly, dealing with the category C titles, just 2 of them.
Yes.
C17 and C25. I'll come back to that point. It says C24 in the grounds of appeal. It should say C25. That's a typo. And then after that, I'll be dealing with what is probably going to be the substantial, most complicated issue, that of adverse possession. That's grounds 4 through 6. But I'll take them really as a
well, that all sounds fine, Mr. Moran. Can I just raise a couple of points? Firstly, I imagine you and Mr. Wynne-Finch have agreed a suitable division of time between you.
We haven't actually, but I'm.
Well, if you haven't, I mean, obviously, I would expect you to reach an equitable.
Yes, obviously, I expect to finish today, probably before the end of today, thereby allowing me a certain amount of time for reply.
Yes.
Particularly in relation to the respondent's notice and their issue about mapping/claim of.
On the question of the respondent's notice, can I just double check? I haven't detected any responsive supplemental skeleton from you on that.
No.
Is that correct?
That is correct. Okay. There's a simple point being it's a pretty simple answer to that, which I'll be just dealing with in normal submissions.
All right. That's fine. The other question was, I was wondering whether any arrangements had been made or could be made for a transcript.
I don't think they have. Let me check.
Yeah. No.
I
mean, obviously, it's not a requirement, but in the case of this nature, it could be, I think, quite useful for the court to be supplied, not with obviously an immediate transcript, but yes. I mean just one taken from the live stream or transcribed in the usual fashion.
Yes.
Just to ease the note taking.
Yes.
Yes, of course. No need for an instant answer, but if that could be organised, I think that would be much appreciated.
Yes, I can understand.
But equally, if it can't, then no problem, and we'll just
absolutely
scribble away.
So, on that basis, I'm going to turn to the Category A reservations, and 2 different places you can see them, but the easiest place to read them is in the core bundle at tab 16B.
Yes.
And 16A is a sample of them. It's marked out where the reservation appears in red line, but it's easier to read on an abstractive title, which is at 16B.
Yes.
What happens is, so broadly speaking, what happened was in about 1919, there was an auction of large parts of the Williams-Wynn's family's lands. And the sales took place on effectively standard terms. There were some very minor tweaks between them, whether or not the word "and" was used in certain places, whether or not the word "in" was used, or whether "within" was used. But essentially, they took place on standard terms because there was a print. In most cases, there was it was set out in the auction particulars, and then it was put into the conveyance. And the particular reservation starts at page 204. Well, it starts at page 204, but starting at page 203.
Sorry, just before we get to the reservations, I mean, the land itself, obviously it's in North Wales,
Yes.
but I mean, do we actually have, I mean, all I've found so far in the way of a map is a very small scale one attached to, I think it's the Particulars of Claim, which is so small it's almost completely illegible.
Yes, the actual full map is in A0 format, and we can get copies of those in A0 format to your lordships if you like. We just, for these purposes, we put in A1. There is a slightly more legible version in, bear with me for a second, supplemental bundle C, at page, tab 27, page 448.
There it is. I'm not sure I feel very much more enlightened.
No, it's not a huge figure. I will see if we can get A0 copies, and there is...
I see at least the red boundaries are visible on this, so everything edged in red is basically part of the estate, is that right?
Well, those are the titles, the land registry titles, as against which we are making claims. But it's not, in all cases, all of the land titles.
No.
So, for example, if you look at right at the bottom left edge red, you can just about see it says B12.
Yes, yeah.
And at the top northern part of that, there's a blue bit.
Yes.
Now, blue is not actually in relation to this appeal because that was a particular type of conveyance, but that was claimed only the blue bit. Just to the right of B12, continuing on with the blue, you see that it's C13, and that's a mixture of blue and yellow, and in fact, it's a little bit difficult to see. There was a tiny patch of green, I think, in that one as well.
Yes.
Now, the dark green, which is a bit more complicated than the pale green. The green is effectively tracks over which we say the category A reservations took place. The yellow, or blue is category B, yellow is category C, and purple is category D.
I'm not sure the colours quite come through on my version, at least I'm not clear what the dark green is, but at least I get the general idea.
The problem is that there's dark green for our claims. There's also certain areas where you've got trees, which makes the green slightly different in shade.
Yes.
I will get A0 maps like this prepared and sent across to your lordships.
Well, that would be very kind if that's not a major inconvenience.
I'm grateful. That will probably take a few days. Printing A0 is a little bit more complicated, but we'll do what we can.
Can I just make sure, Mr. Moran, all the property in issue in this case is on that map that you've shown us?
Yes.
Okay, thank you.
And we're talking something like, I think, we're talking an area which is, approximately speaking, 50 miles square. So 50 miles from north to south, probably about 30 miles from east to west. Something in that region.
It just helps to get a feel for the scale.
Absolutely.
That's really all I was.
Absolutely.
And also the location. I mean, just in relation to a map of Wales, where are we? We're near the top in the middle. So is that roughly speaking?
We are northern, approaching the coast, but quite a few miles from the coast.
Yes, thank you.
So 1919, post-World War I, as with quite a few landed estates, we have a situation where the estate is selling off land, and it does so under relatively standard terms. And the reservations made were all almost identical and came in the form as at tab B, sorry, 16B at page 203 to 204. And this is an abstract title which records, from a later period, but which records a 1921 conveyance following on from the 1919 sale, auction. And you'll see at the bottom of page 203, it's witnessed that in consideration of £8,100 paid by the purchaser to the vendor, at the direction of the vendor is beneficial owner, over the page, in exercise of all and singular, in exercise of all its powers, it's slightly cut off, granted and conveyed to the purchaser, his heirs and assigns, all and particular hereditaments and premises specified in the first schedule thereto, so that's identifying what it is, excepting and reserving unto the vendor and his successors in title, or heirs in some versions, under the said settlement of his and their assigns. 1. All mines, beds and quarries of coal and ironstone, and all other metals, stone and minerals within and under the hereditaments and premises thereby conveyed. Now that's the reservation.
Yes.
And the fundamental question on the category A is, what does stone mean? You read on, though, to give it a bit more context for the assistance of interpretation. Together with all, and this is reserving, together with all necessary or proper powers, rights and easements for searching for mining, working, getting and carrying away the same, whether by underground or surface workings, including the right to let down the surface, whether built upon or not, proper compensation, and this is important, proper compensation being paid to the purchaser, his heirs or assigns, for all damage done to the surface or the buildings thereon, and for the occupation of the surface in or about the exercise of such rights and powers. And then it goes on to see how you quantify that, but that's not particularly relevant for us.
Yes.
We say that this is an absolutely clear and straightforward reservation of, amongst other things, all stone. And the rules on interpreting documents, such as a private conveyance in 1919, are clear and well known. And for our purposes, the really essential one is this. Where the parties have used unambiguous language, the court must apply that unambiguous language. Now, this is more than well known to the courts. It's in Rainy Sky. There's a nicely put version in the Al-Sanar case, which is Authorities tab 19, which is an Authorities Bundle 2, tab 19.
Is that where Lady Justice Aspin provided a useful one-paragraph summary? Am I thinking of the right case? Or anyway,
no, it's not Lady Justice Aspin, I'm afraid.
No,
I think this one was, it might be Lord Justice Gross. It was Lord Justice Gross.
Okay.
Tab 19, Authorities Bundle 2. Paragraph 31. I mean, nowadays there are multiple places one can find this in the authorities, but it is worth just looking at this particular version of it because it really sums up the point that we're making. So paragraph 31 starts with, it's common ground to be interpreted in the way of iterative process in accordance with Rainy Sky. A discussion of Rainy Sky, and it goes on. Sub 1, ultimate aim of construction is to determine what the parties meant by the language used, which involves ascertaining what a reasonable person would have understood the parties to have meant. Reasonable person is taken to have all the background knowledge which would reasonably have been available to the parties in the situation in which they were in at the time of the contract. And the court has to start somewhere, and the starting point is the wording used by the parties in the contract. And 3, it's not for the court to rewrite the parties' bargain. If the language is unambiguous, the court must apply it. And this really comes down to what we say has happened at first instance. The court has tried to rewrite the bargain because the court thought this was an impractical interpretation. And we say, well, first of all, it's not impractical, but secondly, it is not ambiguous. There is no opportunity to rewrite it because it means literally what it says with no room for doubt. Now, it goes on, where a term of contract is open to more than one interpretation, it's generally appropriate for the court to adopt the interpretation which is most consistent with business common sense. And of course, that's straightforward. But you have to have an opportunity for a different interpretation. Now, you get that opportunity with words such as minerals, which are minerals is an inherently difficult word. It has lots of possible meanings. It's used in different ways in language. And you can see that in the Earl of Lonsdale against Attorney General, which is at tab 13. And the Earl of Lonsdale is a very useful authority because in it, Mr. Justice Slade did a very impressive summary or assessment or work through of all the different authorities on minerals. It's worth taking the lordship to it to see where this goes. Having worked through pretty much almost exhaustively the authorities on minerals, very, very good judgment. You turn at page 900, sorry, tab 13, page 924.
Yeah.
Where Mr. Justice Slade says, at the end of this long investigation of authorities, the conclusion which I reach from this may be quite briefly summarised. One, though, in the wide sense given the phrase mines and minerals by Lord Bromley and Midland Railway against Checkley, is a sense which the phrase is capable of bearing and can still be attributed to it in a proper context, it cannot now properly be regarded as a primary or literal sense, which is always to be applied in the absence of a sufficient clear contrary context. Two, and this is the point, the phrase mines and minerals is not a definite term, but is one that is capable of bearing a wide variety of meanings. One possible meaning that had been attributed to the word minerals in Darvel and Roper and other pre-1880 authorities was all such substances as are dug out of the earth by means of a mine. This remains a possible meaning in a proper context. So with something like mines or minerals in particular, it's an ambiguous term. You're looking at the different interpretations and you're deciding which one is appropriate in the commercial, amongst other things.
Well, I quite understand that, but may it not be said that stone is also capable of differing meanings? And one immediately thinks of possible problems about, for example, gravel or clay. I mean, are they stone or aren't they?
Well, the first point is, your lordships are not being asked to define stone. Your lordships are being asked to work out if mudstone is within the definition.
Well, that is so, but in order to answer that question, we have to understand what the definition embraces.
But that means that whilst there may be a debate as to whether gravel is contained within stone, once you get a substance that is undoubtedly stone, your lordships can't exclude that from the meaning because it's not ambiguous.
Well, that depends, doesn't it, on what counts as stone in this particular context.
It's difficult to see that there is a possible alternative, and I recognise that.
Yes.
But it's difficult to see there is a possible alternative to mudstone being stone in this particular context. We can see it in a couple of different ways. First of all, mudstone, three different ways. First of all, mudstone, by its very nature and name, tends to be stone. The second point is, even the defendants have acknowledged that it's stone. And you can see that in their defence. So if you take the core bundle and you turn to tab 12, page 159. You get paragraph 8.1 of the defence, as to paragraphs 10 and 11, and this was where they pleaded effectively limitation. For more than 40 years past, the defendant has openly, without force and as of right, quarried stone, but not other minerals, from wherever it likes on the land, without any objection.
Yes.
And then if you turn on to page 161, paragraph 14. Paragraph 18, if it's not necessary to claim, this is a Human Rights Act which isn't live in the appeal. Nevertheless, the defendant pleads those allegations as follows. Sub 1. The stone quarried by the defendant has mostly been used to improve roads. They're talking about the mudstone.
Yes.
Now, that's the first thing. The second thing is, you can see by the way the judge has applied her mind to this, the way the judge has described these matters, that there is no ambiguity that mudstone is stone. And you can see this in the factual findings of the judgment. So if I can take your lordships back to the judgment, which is at tab A, page 81. And start at page 98. Paragraph 66. So having been describing paragraphs 61 through 65, having been describing mudstone in its use and its uses, you get to paragraph 66. In the past, quarried mudstone would also have been used to construct mine infrastructure in the area. The miners would, in practice, have had to use the local stone for this purpose. So she's clearly applying mudstone as stone. But there's also the further point, which is even if there were any doubt, by the time you are using mudstone to build mine infrastructures, including cottages, as we will see, by the time you're using it to build mine infrastructure and cottages, this has to be stone. There isn't any ambiguity possible to say that it's not stone.
Isn't it a question of context? Something that may be described as stone in one context is not necessarily to be described in stone in a different context, is it? Unless it's your submission that the word stone is incapable of being construed differently according to context.
There is going to be, as with almost all English language, a possibility of context making a difference to the particular meaning. But there is no ambiguity in this particular context about the bedrock mudstone, which was used to construct cottages and mine infrastructure in pre-1919. And we do not see that there is an argument to say that stone means anything else.
So is it your submission that the word stone has a meaning which is not dependent upon its context?
It has a certain core meaning that's going to be independent of the context. You can't, for example, unless you were using a very peculiar private dictionary situation, you couldn't describe wood as stone, for example. It would have to be some sort of mineral body that was hard.
Mr. Mann, what bothers me is you could say the same about mineral. It's a perfectly true and unambiguous statement to say mudstone is a mineral, but it doesn't mean that it falls within mineral in the relevant context.
The difficulty is you've got to find an alternative meaning of stone in this particular context. To say that there are two possible meanings.
To say that it's unambiguously true that mudstone is stone is the same as saying it's unambiguously true that mudstone is mineral. They're both unambiguously true. And they tell you when you make the statement, it tells you something about the way you've used the word in the utterance you've just given, but it doesn't necessarily tell you what another different context in which the word is used necessarily covers or not.
Fair enough, but in this particular context, there is not an ambiguity.
Okay.
So,
well, you may have perhaps indicated that there is one by your reference to bedrock. I mean, one of the problems in this case is, well, probably at an intuitive level, we could mostly agree that bedrock mudstone is stone. On the other hand, what do you say about detached pebbles which one finds in the soil?
Okay, that point.
Or loose boulders in the fields, or outcrops.
Well, outcrops, if they're still part of bedrock, are going to be bedrock and stone.
Yes, okay.
Detached pebbles, I can see an ambiguity because of the size of the piece, whether or not you're talking about stone in this particular.
Well, indeed, the soil itself is made up of microscopic particles of stone and much else,
Yes.
is it not?
And at that point, I can see that there is, in that particular context, a question of what does stone mean. But in terms of bedrock, and that's what we're saying, in terms of bedrock, it is difficult to see that there is any interpretation of stone that does not include bedrock.
Is your claim confined to bedrock? It doesn't stay so explicitly.
Well, we are saying that that is what the meaning is, yes.
Is that the meaning that was advanced to the judge, or is this the way you now?
That's the meaning that was advanced to judge. We said, originally we said in the skeleton it was subsurface, but the expert's evidence divided up, you've got surface and then you've got regolith. And we
Yes.
said, okay, regolith is a mixture of whether or not it's subsurface or surface. So we say bedrock, and we'll include that below the regolith.
So you break a bit off, does it stop being bedrock?
If it's broken off the bedrock, then it's no longer bedrock.
Isn't that what regolith is?
Yes, they're bits, amongst other vegetable or organic material
Yes.
mixed in with it. Yes.
And what about an outcrop? I mean, you accept that the surface is concluded in the conveyance. What does that mean if you're talking about an outcrop? Presumably by walking on an outcrop, you're not thereby trespassing on the...
No, you'll get the surface.
Well, what does the surface, I mean, how far down does the surface go for these purposes? When does it stop being surface and become a reserved mineral, or reserved stone, sorry, I should have said.
Okay. It's going to... Let's just for a moment say that the reservation was, in the words, the bedrock mudstone. Say the reservation is we reserve the bedrock mudstone. When you get the surface, you get literally the surface and all above it.
Well, I'm sorry, I'm not clear what literally the surface means. I mean, does it mean a millimetre deep, or a centimetre deep, or, you know, or what?
Well, in this particular case, it would be the area above the bedrock, immediately adjacent to the bedrock.
What if the bedrock is exposed and bare?
Then you get on top of it.
So you can't then walk on it
You
without
can,
committing a
because you've got
trespass?
the top of it. You're immediately above it.
As soon as your boot depresses into it, then you're trespassing.
There might be a theoretical trespass on that. But if it says bedrock mudstone, then that's what you get. And it is a bit peculiar, but it's what it says. And it is possible, I can see it is possible, that there are going to be peculiarities of this. But if it said bedrock mudstone, and bedrock mudstone is exposed, then the bedrock mudstone is reserved. And if the stone, if stone in this particular context unambiguously includes bedrock mudstone, then that is what is reserved.
Unless
Because if it isn't, then where does it go? You don't have anything. You've got a difficulty about the application at the surface, you don't get anything. It's not ambiguous, it's just unexpected in many situations. Now, I suppose also you'd, in response to Lord Justice Arnold's question, if you'd get, when you get the conveyance under the law, of course, I'm not quite sure in 1919, but if it was done today, you'd get the necessary implied easements over any retained material. Section 60-something of the Law of Property Act, I think. 62, thank you.
I mean, I'm not suggesting there may not be answers to these points. It's just I'm really attacking your absolutist proposition that stone means stone, basically.
Well, stone means stone is sufficiently clear and unambiguous to include necessarily bedrock mudstone in this particular context. Now, I want to carry on taking your lordships through the judgment to show how many times the word stone is used in this context. So, paragraph 66, we've already seen. Turn over the page to page 99. Paragraph 71. You get Mr. Trumper, that's one of the defendant's witnesses, also explained in oral evidence that to him forest road and tracks are interchangeable terms, however harvested tracks are also constructed. These are shorter lengths of track that weave in and out of trees to aid harvesting and processing. This was consistent with Mr. Fletcher's evidence, another one of the defendant's witnesses, which referred to building both stone tracks and ramps for harvesting. Mr. Trumper explained that harvest tracks were also constructed with mudstone, but more roughly than the main roads or tracks, using bulkier material of the lowest grade. Mr. Fletcher explained that where possible, stone available on site would be used for tracks and ramps. And down at the bottom of that page, at paragraph 72, you get the judge finding, 4 lines down, halfway along, I conclude the forest roads and tracks within virtually all cases have been at least widened and upgraded since the date of acquisition. And if you turn over the page, it talks about widening, upgrading, and building from scratch. Turn over the page, top of the first line at the end, all of these activities, together with routine maintenance, not only require stone to be used, and that's mudstone, but as described further below, will have caused at least some disturbance to mudstone in situ. And then turn over the page, page 101, paragraph 80. Last sentence, 3 lines from the bottom, halfway along. As already mentioned, in the past, quarried stone would also have been used to construct mine infrastructure in the area and no doubt for other local building and construction work. And that's going to be mudstone because it's the ubiquitous local stone of the district. And then you go on to page 108. Paragraph 106. Mudstone is without doubt the common rock of the district. So if somebody is in this area looking at what the word stone means, it's going to be mudstone. And it's very difficult to get away from the fact that anybody looking at the common rock of the district that is used for building and it's used for construction of mine infrastructure, cottages, roads, etc., and is talked about as stone, is stone. Or to put it another way, it is difficult to see a definition of stone which excludes that. And it's not, you have 2 different interpretations, take the one commercially most sensible. It's you've got to get the second interpretation that excludes bedrock mudstone before you get to see whether or not it's an alternative potential.
Yes. Well, one possible exclusionary construction could be that the word stone in this particular context doesn't include the prevalent stone of the district, or doesn't extend to types of stone which are of no widely recognized commercial value. I mean, of course, they can be used for various purposes where it's at hand and there's no alternative.
But that would be ignoring the actual word stone. You'd be having to think up another word.
It wouldn't. It would be accepting the word stone, but also going on to say it doesn't have an unqualified meaning. In other words, a qualification can be derived from the context. In theory, I'm not saying that's necessarily the right approach. But
you'd have to... Before you get to that, you've got to realise that there has to be an alternative interpretation. There has to be an alternative interpretation for it to show that it is ambiguous. And whilst there are alternative interpretations for the word minerals, there aren't really alternative interpretations for the word stone as it's being used here, repeatedly.
Well, that's rather the question, isn't it?
Well, we say that...
You assert that as though it were, I was going to say written in stone, but you know what I mean. Sorry.
Yes, that's a fair point. One further point. There are a couple of other references in the bundle in the judgment to the use of the word stone in this context, and stone and stone and stone.
Yeah, I'm perfectly prepared to accept that in ordinary speech one might well use the word stone in various contexts, including in the expository passages of a judgment, to describe mudstone.
And they are using it here
to
describe mudstone.
I quite understand that, yes.
In order to get to an alternative interpretation that doesn't include mudstone, it's difficult to see how you get there. That's the problem. They've got to exclude it somehow as an alternative interpretation. And then you've got a final point, which is at page 129. C17. And this was a particular reservation. And in this case, again, the claimant's claim is in respect of part owning title. One part, the southern parcel, is subject to an A-type exception and reservation. pursuant to a conveyance made in 1924, which contained an exception and reservation in similar terms to that contained in the sale that followed the 1919 auction. Mr. Moran relied on the express power included in this conveyance, unlike other A conveyances, which allowed the defendant's predecessors to extract stone for building and roads on site, and not for sale or use elsewhere, as showing that it was understood at the time that an express right was needed. Carries on. I disagree. It's equally consistent with the purchaser or his advisors being cautious and wanting to spell out explicitly that the normal use of mudstone contemplated at the time, as in use of the immediate vicinity, was not prevented. But if that is the case, and they're using the word "you may extract stone" in reference to mudstone, that must be that mudstone is stone.
Yes.
And then, if I can turn back to the actual words of the reservation in this particular case, tab 16b. You can then go through the words itself as an aid to construction. Page 204. Accepting and reserving to the vendor his heirs all mines, beds and quarries of coal and ironstone. So that's limited to mines and beds of coal and ironstone, because then you get another "and" all other metals, stone and minerals. Now, in that second "and," not operating as an Oxford comma "and," you get a distinction from the railway and canal cases, where that was discussing minerals. The reason I say that is that the railway and canal cases went along a particular style. And if I can take your lordships to the authorities bundles, tab 1.
Sorry, which tab?
Tab 1, you've got a railway clauses
tab one,
consolidation.
sorry, yes.
And it's the company shut, and this is replicated in a variety of different situations, but also replicated pretty closely in Canal Acts as well, Waterworks Acts. The company should not be entitled to any mines of coal, ironstone, slate, or other minerals. And then you turn on to tab 6, which is the case of Lord Provost and Magistrates of Glasgow against Ferry, which is a Waterworks Clauses Act. You'll see at the page 657, the first page, similar restriction: the undertaker should not be entitled to any mines of coal, ironstone, slate, or other minerals. Yes. And then if you turn on to page 678, at the bottom, see Lord Watson discussing this. Last paragraph. I'm accordingly of opinion that in the India's enactment, the word mines must be taken to signify all excavations by which the accepted minerals may be legitimately worked and got. If coal, ironstone, or slate crops out at any part of the surface taken for waterworks or railway purposes, the undertaker of the company acquire, in my opinion, no right save the right to use that part of the surface. They acquire no right to the minerals themselves, except insofar as these are dug out or excavated in order to construct their work. So that's an example, my Lord Lord Justice Arnold's point. You get the use of the surface, but you don't get the rock itself. The important question still remains what are minerals referred to other than coal, iron, stone or slate? My present impression is that other minerals must necessarily include all minerals that can be reasonably said to be a justem generis, with any of those enumerated, slate being one of them. I don't think it'd be possible to exclude freestone or limestone strata. So you're saying you've got to go back, in that particular context, doing a justem generis interpretation. It's different in our case, because you've got the separation of mines of coal and ironstone, and then you've got and all other stone minerals, etc.
Well, perhaps another way of looking at it, though, is to say you have basically the same list, but just with stone added into it. So it may not be said that stone then takes its colour from the surrounding terms, and does, albeit there is the copulative and, does nevertheless allow for the possibility of some kind of a justem generis construction.
Right.
In other words, looking at things which are commercially worthwhile to exploit.
Could you turn on to tab 8, which is the North British Railway Company against Bloodhill? This is an interpretation of the Railways Clause as consolidation again. But then you get at page 132 to 133. Was this the right page? Hang on. Sorry, no, wrong tab. Tab 7.
Earl of Jersey, is this the one?
This is, yes, Earl of Jersey against Guardians underneath the Poor Law. And you see in this one, it was a conveyance in the opening passage or headnote. A conveyance in fee of land reserved all mines of coal, coal, iron, and all other mines and minerals whatsoever except stone quarries. And then if you turn on to page 565, Lord Justice Fry, second hole punch. 1, 2, 3. About 12 lines up. Line starting compensation to persons who claim under the grant. We have therefore in the second. Sorry, no, little bit line beginning which deprives Mr. Jelf's argument of its hovels. There is only one other point which has been urged upon us, to which I need refer. We've been asked to apply what is called the doctrine of a justem generis, and to hold that the word minerals must have a restricted signification. Now, the words of reservation are these: all mines of coal, coal, iron, and all other mines and minerals whatsoever except stone quarries. Now, in the first place, I think that the words all other mines and minerals whatsoever are intended to mean that which they express, and where you find the word whatsoever following, as it does on certain substantives, it is often intended to repel, and in this case does effectually repel, the implication of the so-called doctrine of justem generis, which I think has often been urged for the sake of giving not the true effect of the contracts of parties, but a narrower effect than they were intended to have. But further than that, it's to be observed that there is an exception to these general words, an exception namely of stone quarries, which is useful in showing the generality to which the words have been used. It prevents any idea that the words minerals should be confined to anything like coal, coal, or iron. That is to say, to metalliferous minerals, which I suppose is the only argument which could be based on the doctrine of a justem generis. The exception tends to show that, but for the exception, stone not being metalliferous would be included in the reservation. Now, coal and ironstone, trying to identify what their genus is in this particular context is difficult. They're going to be, coal and ironstone are going to be carboniferous, maybe metalliferous. But it's not a particularly identifiable genus. I can't personally see that would cover anything other than coal or ironstone.
Well, one can see the argument that both coal and iron are valuable commodities which are worth mining and extracting, and turning to account in a way which can lead to profit for the person who is lucky enough to own them.
And by 1919, it's well understood that minerals covers that.
Indeed.
So why add stone?
Well, it may be, again, see, where do you draw the line? I mean, the learned judge was inclined to accept that a seam of sandstone of workable size and thickness might be covered by the word stone in the context we're talking about.
Yeah.
But she contrasted that with mudstone and also with the very thin layers of sandstone, which were not really commercially viable, although they do occur in some locations.
The point I was making, my lord, is this. If you've covered valuable minerals, which will include sandstone, what do you add by adding the word stone? If valuable stone is covered by minerals, as it should be, it's slate, tin, that sort of thing, then you're adding nothing by including the word stone.
And the answer to that surely is that minerals is widely accepted to be an exceptionally chameleon term, which can have all sorts of meanings depending on the context. So, and given the love of all draftsmen of conveyances to use a torrential style of never using one word and three will do, they tend to put in stone as well.
Well,
just to make it abundantly clear.
There is a possibility that it's waterfall drafting, but we say that in order to give meaning to that actual word, as the tenets of construction says one should, it goes further. In this particular context, if minerals means valuable materials that can be extracted, which will include valuable stone, then stone adds something else to it. And it's not just stone and minerals, it's all other stone and minerals. Not other valuable stone and minerals, all other stone and minerals. In a context where people are using this material for building houses.
Can I give you a suggestion for a genus which coal and ironstone have, which metals also has, but stone doesn't, which is that to use coal and ironstone, you have to extract it and do something to it. You have to burn the coal, you have to take the iron out of ironstone. But stone is something you take out as blocks and use it in a completely different way. So you could miss one possible reason for putting in the word stone there is to make sure that that what you're quarrying out isn't just stuff that you have to process in order to use it, but also includes blocks that you can use to make, which is what stone is, could be telling the reader you're covering.
So that's one possible distinction, but that doesn't assist on the justum generis analysis.
Oh, but I was just you
limited to it. Sorry.
Just because you were suggesting there wasn't a genus, and I'm just suggesting maybe there is.
If there is a genus, then that's not a genus that can be usefully applied to limit stone, and that's the justum generis rule. If you've got particular words followed by general words, the general words follow on with the narrower context of the particular words. If in this particular context we're saying you have particular words and we're adding this in to go wider than the particular words, then that's the opposite of the justum generis principle. If that's the case, and if you can find a genus, then it doesn't assist on.
I get that. Forgive me. The point I was trying to make, and forgive me for muddling it up, is that it's showing you that, as it were, the word stone can do work to deal with that kind of justum generis construction, but in a way which doesn't lead to the conclusion you're talking about.
Okay, first of all, it's all other stone. It's not stone that's going to be taken out of blocks. Secondly, whilst the justum generis works as you're trying to identify what people are talking about, if you're expanding on it, the question is, how much more are you expanding?
Sure.
And I don't see how that could limit the definition of stone, rather than give you a reason for saying this is stone.
Okay.
Now, the impracticalities that are argued, we say, aren't realistic. And you can see that partly from the context in which we're talking about. Stone was always used by people. These were primarily agricultural lands, farmers, sheep. And although there are a few places with buildings and there are a few places with woods, it is primarily sheep farming. In those contexts, not owning the bedrock is not going to be of any significance. And then, you've also got the issue of how is this going to interfere with enjoyment of the surface? And the respondent says nobody would ever think about buying a property like this, if they thought that it might be mined, they might lose their house, it might collapse, or so on and so forth. First of all, it's highly unlikely that's going to happen. But secondly, even if there is such an event, it's dealt for or dealt with already in the reservation. So going back to 204, Core Bundle 204, and it's the compensation provisions. And you get that, page 204, where it talks about you've reserved all the mines, beds and quarries of coal and ironstone and all other metals of stone and minerals within and under the herediments and premises thereby conveyed. And then you get also powers of working, together with all necessary or proper powers, rights and easements for searching for mining, working, getting and carrying away, the same, whether by underground or surface workings, including the right to let down the surface, whether built upon or not, proper compensation being paid to the purchaser, his heirs or assigns, for all damage done to the surface or the buildings thereon, and for the occupation of the surface in or about the exercise of such rights and powers. And for that, there are 2 points you can draw from. First of all, in practical terms, if there's any damage done, they'll be compensated. So if the house does collapse or the house is dug out, you've got to get the price of the house or the price of restoration. And secondly, it is only in relation to the surface. It doesn't give compensation for digging through other seams which are owned by the purchaser. And it indicates, we say very strongly, that what the purchaser is getting is the surface.
What is the surface in this context? I mean, in mathematical terms, a surface has no thickness at all. But clearly, in the real world, when we speak of surfaces, we are, generally speaking, depending on the context, speaking of things that do have a depth.
Yes.
And the question, therefore, is what is, in your submission, meant by surface in this context? Now, earlier, you appeared to be submitting that the surface was to be equated with the mathematical concept.
On an outcrop, if you're talking about the pure surface, that would be the mathematical area. But otherwise, you'll be talking about the non-bedrock, the regolith, the soil. Because that's the part that's not reserved. But the point I'm drawing out here is, it's difficult to see that there's an interpretation of surface that is going to include bedrock mudstone going down meters. Or hundreds of feet.
I mean, your definition, which confines stone to bedrock, one doesn't get that from the terms of the conveyance. I mean, this is already a very major gloss which you are imposing as a matter of construction on the otherwise clear use of the word stone, I would have thought. So aren't you really, by making that submission, accepting the point that stone can't be, as it were, construed in the absolute?
No, we're saying that it must necessarily include this. It's not we're saying it can't include other things, it must necessarily include this, though. And whilst there are situations in which the question of stone might be ambiguous, it's not ambiguous in the context of whether or not bedrock is included in it. But even if there is an ambiguity, that ambiguity doesn't extend to a possibility of the bedrock not being stone. And it's not impractical, the way that we put forward. It works entirely coherently. There's proper compensation provisions. It's a usable estate that is passed over. there's an entitlement to let down the surface. If you can do that for tin, why can't you do that for mudstone? Or if you can do that for slate, or granite, or some other valuable material, why can't you do that for mudstone? So the impracticalities that are alleged against us aren't impracticalities. They're just something that's already been dealt with and agreed to in the contract. And as I say, that since the compensation only goes to the surface, we say that's a strong indicia that the purchaser is not purchasing anything below that. And if that's the case, that goes further in supporting the fact that it is unambiguous that bedrock is going to be stone within the reservation.
What about that element of the ground in which the foundations of his house are placed?
Now that's going to go with the house as part of the house.
What about the garden?
Garden is surface. Not quite sure
The
where you're...
roots of the plants.
Roots of plants? It's going to be in the soil. If and to the extent that it starts extending into stone, then you don't... then you have roots extending into somebody else's property. But if you have an apple tree at the corner of your garden and its roots extend over to your next door neighbour's garden, it doesn't say that your next door neighbour's garden is suddenly yours. Or if you have Blackacre and Whiteacre with an apple tree next to on Blackacre that extends the roots into Whiteacre, and you sell Blackacre, it doesn't mean that you're actually selling Blackacre and a bit of Whiteacre. You're still defining what it is by reference to the plot rather than where the roots are going.
As I understand it, one of the physical qualities of mudstone is that it's very friable, and if it gets wet, basically it's liable to disintegrate, or at any rate, very often is, which must mean its use as a building material is very much faute de mieux, and not something which one would do unless absolutely no alternative presented itself. So I imagine, although various forms of house, perhaps connected with mining operations, were built, they were pretty low-grade buildings.
But it's what you would have been doing in the area.
It may well be what you had to do in the area if you weren't rich enough or were so poor you couldn't afford any alternative.
Yes.
And I suppose by making an overlapping roof of some kind, that would help deal with the problem of damp. But even so, it's a pretty marginal use, I would have thought, in commercial terms.
I'm not so sure about marginal use. It's quite widely used.
Well, I'm speculating, frankly. I don't know. No doubt there was evidence on all these
The
points.
difficulty is, we've got a finding of fact that it was used in mining infrastructure,
Yes,
building,
yes,
and
I
construction
follow
of buildings. It is the stone of the district, or the rock of the district. It's difficult to get away from the fact that this is how it was used at the time. In fact, one cannot get away from the fact. It's a finding of fact.
Now, you've got that finding in your favour. Can you help me on this, though? Was there any finding as to whether or not people paid for it?
No.
So there's no finding one way or the other?
No finding one way or the other.
Right, thank you.
So, Lords, I don't want to drag on with this particular point. I think you all should have my points, which is...
Yes, we do.
It's clearly understood that this is stone in general parlance. There is no reason in this particular context for limiting it. It's not impractical. The terms of the reservation cover any impracticalities that might be alleged. It's used at the time. It's understood how it's used at the time. And this is how it's described. In that context, we are not in a situation where you have to choose between competing definitions of it. The only way that you could get to that would be by saying the outcome is so bad we have to look at whether or not this is actually what was intended. But the outcome is not that bad. And, as I say, whilst there may be some situations in which the word stone is, or the application of the word stone or the definition of word stone is borderline, or there are alternatives as to whether it applies or not. In terms of the bedrock, it is, we say, quite clear that that is not one of those situations. It must be within the meaning of it, and the court must, irrespective of how it feels about the bargain, apply that meaning. Although, and I do emphasise, that's not actually a particularly bad bargain in this particular context.
Yes, thank you.
So, that's the category A, and on that basis we say that the learned judge at first instance erroneously excluded mudstone, the bedrock mudstone, from the reservations. Round 2. She also excluded it from the operative reservations in the 1816 Arusli Act. And you find the wording of that is at Authorities Bundle 2, tab 24. Oh, sorry, tab 24. And it's at page 756 of the statute, clause 67. And I'm going to take your lordship through the statute in a little bit more detail in a few minutes, but I'll just start with the reservation.
Yes.
Reference.
Thank you.
Provided always, so reservation of mines is the sidebar. Provided always, and be it enacted, that nothing herein contained shall prejudice, lessen, or defeat any right, title, or interest. Note those 3 words, which the person who shall or may hereafter be entitled as lord or lords of the said manor now have or hath, and again note those words, have or hath, or shall hereafter have in or to any mines, ores, coals, metals, or minerals whatsoever in or under the said wastelands within the said manor of Rustling, or any part or parcel thereof. But that, so that's the reservation of the mines, ores, coals, metals, or minerals. And then you get the powers of working. But that it should be lawful to and for the said lord or lords in and upon the said wastelands within the said manor and the future lord or lords of the said manor in upon the said wastelands at any time or times hereafter according to their respective rights to delve, search for, get up, make merchantable, and take and carry away with all or any manner of carriages to their own respective uses the said mines, ores, coals, metals, and minerals, or any part thereof. And then goes on, you can also erect machines, roads, ways, sumps, levels, warehouse, engines, and other convenient machines and convenience erections, and do any other acts which would be necessary or proper for any of those purposes. And the same, warehouses, blah, 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 take them down as well. And then 4 lines from the bottom, starting pleasures, the lord of the said manor, and the future lord or lords thereof respectively, making full satisfaction from time to time to the respective owners and occupiers of the said allotments of the said wastelands for the spoil and damage which shall be done or occasions thereon by the exercise of all any of the said powers. So you've got a reservation that, as to title, right, or interest which they have or hath, and then you've got powers of workings, and then you've got provision for compensation. Now, we say, and we'll go through it in a moment, Ross and Wynne-Wynn, on the basis of Ross and Wynne-Wynn, that is clearly encompassing stone. And the reason being, in a nutshell, that enclosure acts were designed to allot the surface to the copy holders, and in this sort of situation, to retain everything thereunder. That was the political and financial purpose of it, and that was exactly what this did. Now, the 2 counter-arguments to that, first one being minerals means something valuable, etc., we say is answered by the authorities on these words or similar words in enclosure acts. as well as the purpose of it, of an Enclosure Act. And the second being that this is supposed to be, that the allotments that the Lord of the Manor obtained in respect to their rights or interests was in full and final satisfaction of their interest thereunder, and this doesn't have what are described as the magic words, which I'll come back to in a moment. The magic words, you can see equivalent magic, so-called magic words at clause 68, which is saving manorial rights. So in most Enclosure Acts, you have savings of or reservations of manorial rights, such as rights to hold courts or strays, waifs, deodans, that sort of stuff. So seeing 68, provided always, and be it further enacted, that nothing herein contained shall extend or be construed to extend to give unto the Lords of the Manor any future manorial right, title, or interest than those they now respectively have or are entitled to, nor to defeat, lessen, prejudice, or affect their right, title, or interest of, in, or to rent, services, courts, perquisites, profits, all of these things, listing down royalties, jurisdiction privileges, etc. And then you go down to the bit in brackets, other than and except those meant and intended to be barred, destroyed, or extinguished by virtue of this act. But that the same, every of them shall remain and be enjoyed by the said lord or lords of the said manor, in as full, ample, and beneficial manner, to all intents and purposes, as they could or might have held and enjoyed the same respectively, in case this act had not been passed. And it's the full, ample, and beneficial manner which it's alleged is some sort of magic words that retains something else. Now, we have a couple of answers to that. In a nutshell, there is a distinction between what is being reserved being held, reserved, conveyed, which is where it's talking about nothing defeats, lessens, prejudices, or affects right or title or interest in clause 68, and nothing shall prejudice, lessen, or defeat any right, title, or interest in clause 67. That's the reservation of the interest. And then separately, you have the question of how that interest is to be enjoyed or exercised. And in clause 67, it's got all the powers of workings for the minerals and mines. And in clause 68, it says it will be enjoyed by the said lord or lords of the said manor in full, ample, and beneficial manner to all intents and purposes as they could have. And you'll see that as I come back to it in a short while in the authorities. But the real question is, what does minerals mean? And we say that that's answered by the decision of the, originally the Court of the Exchequer, and then approved by the Exchequer Chamber, so one of the predecessors of the Court of Appeal, in the case of Earl of Ross against Wynne-Finch. The decision of the Exchequer Chamber, which is at tab 26, is quite brief. It effectively says we agree with the decision below.
You wouldn't be very happy if we gave you a judgment in that form.
I don't think we do judgments in that form anymore. Probably.
Temptation sometimes.
Yes, temptation, yes. And then you turn on to tab 27, and you get the first instance decision.
Yes.
Now, the Enclosure Act in that case is set out at page 725. And it's marked up in red on the side that I wanted your lordship to identify. And it says, by an Act of Parliament in the 55th year of the reign of His Majesty, institute an Act for enclosing the lands, township of Bradford and in the West Riding of the County of York, after reciting that there were within the manor and township of Bradford, blah, 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 several commons or parcels of waste ground called, page 860, High Bank and Low Moor, and several other parcels of waste ground continuing the whole by estimation 280 acres, and also reciting that the Reverend Cyril Jackson, D.D., was Lord of the Manor of Shipley, and as such was owner of the soil of the said commons and waste grounds and entitled to all mines and minerals within and under the said commons and waste grounds. So it's quite a standard recital from a lot of, although not all, Enclosure Acts. And then reciting said Cyril Jackson, several other persons or owners of proprietary estates within the manor, and in respect of their entitled to rights of common and other rights and interests upon the common, it was amongst other things enacted. They appoint somebody for doing this, and the Commissioner appointed for carrying the said act in execution should, after setting out and appointing public carriage roads and highways through and over the commons and waste grounds intended to be divided, allotted, and enclosed as aforesaid, set out, allot, and award unto, and for the said Cyril Jackson's law the said manor, and to such personal persons as should then be entitled to the said manor, his or her heirs and assigns, such part or parcel of the residue and remainder of the said commons grounds as should, in the judgment of the said Commissioner, be equal in value to 1/16th part of the said residue of the said commons and waste grounds, in lieu of and full recompense for all such right or interest in and to the soil of the said commons and waste grounds, as what was not thereafter expressly saved and reserved. And we don't have an express saving or reservation in the allotment clause in the Arundel Act, but it's got to be taken with the reservations thereafter, because you read an act as a whole. And it was further enacted that the said commission should, in the second place, set out such waste ground, etc., and then page 861, for cattle and getting stones and other minerals for erecting and repairing bridges, walls, fences, and other works. Again, there's a similar provision in the Arundel Act. And then down at the bottom, you get the reservations. And it was further provided and enacted that nothing therein contained should extend or be construed to extend to defeat, lessen, or prejudice right, title, or interest of the said Cyril Jackson, or any future lord or lords, lady or ladies of the manor of Shipley, in or to the seigneuries and royalties instant belonging to the said manor of Shipley, but that the said Cyril Jackson, and such other personal persons as aforesaid, should and might from time to time forever thereafter hold and enjoy all rents, services, waste, estrays, forfeitures, other jurisdictions, whatsoever in or upon the commons and waste ground, thereby directed to be divided and enclosed as aforesaid, and all mines and minerals of what nature or kind soever, so in our case, all mines, ores, corals, metals, or minerals whatsoever. So quite similar words. Lying and being within or under the said commons and waste grounds in as full, ample, and beneficial a manner, to all intents and purposes, as they could or might respectively have held and enjoyed the same, in case the said act had not been made. Yeah. So that's the holding and enjoying, and then you also get the working powers, and that the said Cyril Jackson and such other personal persons, as aforesaid, should and might, from time to time and at all times thereafter, have, hold, win, work, and enjoy exclusively all mines and minerals of what nature or kind soever, within or under the said commons and waste grounds, and within or under every part thereof. And then there's a large list of things that they can do. And getting down to line beginning, free will and pleasure, if you can see that.
Yes.
And to do, execute, and perform all such other works, matters, and things, either then in use or thereafter to be invented, or should or might be necessary or convenient for full and complete working, use, and enjoyment of the said mines and minerals thereby reserved, in as full, ample, and beneficial a manner, to all intents and purposes, as they might or could have done in case the said act had provided nevertheless, had not been made without any interruption, disturbance, claim, or demand whatsoever. So again, in as full, ample, and beneficial manner is to do with how they work the mines. And then there's a proviso. Provided nevertheless, and this is slightly peculiar, provided nevertheless that the said Cyril Jackson, his heirs and assigns, and his and their tenants should, and they were thereby required in searching for and working the said mines and minerals, to keep the first layer or stratum of earth separate and apart by itself, without mixing the same with the lower stratum. And bear with me for one thing, I've just got to find one particular passage. Yes, actually carrying straight on. And it was thereby further enacted and it was thereby further enacted that all and every such damage and injury as should or might be occasioned in any allotment or allotments which should be set out under that act by means of the searching for or working the aforesaid mines and minerals, or any of them, or any account of any works, buildings, or concerns relating thereto, upon or within the said allotments, should be reimbursed to the owner and owners, occupier and occupiers of the same allotments respectively, and should be borne and paid by the several owners of the allotments to be made in pursuance of the said act. So rather peculiarly, you end up with a compensation provision whereby not the lord of the manor, but all the allotment people are paying for the compensation. Now this may sound peculiar, but it's not absolutely unique in terms of enclosure acts. And when I come back to another case called Consett, you'll see that in another case there were the Prince Bishop of Durham retained mining rights and could do exactly what he wanted, including letting down the surface and completely destroying land. And the people who had to pay the damages was not the Lord Bishop of Durham, but in fact the Justices of the Peace who were allotted a portion of land to do so. So slightly different, but it's not unique. But you would get that provision, and then you turn to the judgment, which starts at page 729. And Baron Park holds, opens with the question in this case is whether the plaintiff, Lord Ross, is entitled to the stratum of stone under the allotments of the waste of the manor of Shipley enclosed by virtue of the Act. Lord Ross is signee of the Lord Manor and has all the rights reserved to him by the Enclosure Act. What these rights are depends upon the construction of the Act, which is not very clearly expressed and is open to much doubt. But the result of our consideration of the whole of its provisions is that, in our opinion, the right to the stratum of stone was reserved to the Lord, and consequently the plaintiff is entitled to recover. It's clear from the recital that, before the passing of the Act, the Lord was entitled to the soil of the waste and to everything constituting that soil, including every stratum of stone. And the question is, how much of this right is taken away and transferred under the Enclosure Act to those to whom the allotments were made? All is taken away except that which is reserved by the saving clause, which is to be construed with reference to the original title of the Lord to the whole of the soil. And then it goes on to that section provides nothing in the Act, etc., etc.
Yes.
Etc., etc. So if you turn over the page, page 730, second paragraph, first full paragraph, second paragraph down. The term minerals here used, though more frequently applied to substances containing metals, in its proper sense includes all fossil bodies or matters dug out of mines. Mr. Johnson says that all metals are minerals, but all minerals are not metals. And mines, according to Jacob's Law Dictionary, are quarries or places where anything is digged. Beds of stone which may be dug by winning or quarrying are therefore properly minerals. And so we think they must be held to be in the clause in question, bearing in mind that the object of the Act was to give the surface for cultivation to the commoners and to leave in the Lord that which it did not take away for that purpose. And now, it goes on to say, this construction is greatly favoured by the last clause, which provides that the surface soil, the first layer or stratum of earth, is to be kept separate without mixing with the lower strata, a provision which clearly indicates that the removal of the surface soil to a great extent may take place and be subsequently restored so that the getting the strata of stone by quarrying must have been contemplated. Now, it does go on to say, it must however be admitted that the provisions authorise the working of mines and minerals and leading and carrying away the lead or blah, 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 ironstone and fossils leads to the supposition that the legislature intended to reserve metallic minerals only and creates much doubt about the true construction of the word in this Act. But the word fossils, in a strict sense, and this is because the word lead or lead, coals, ironstone and fossils appears in the workings provision rather than in the reservation provision. And it doesn't appear in the Orisley Act. But the word fossils in the strict sense may apply to stones dug or quarried. At any rate, we do not think that this provision so clearly indicates the intention of the legislature to limit the proper meaning of the word as to call upon us to do so. We place no reliance on the word minerals being connected with stone in the 18th section, different section because it probably actually meant material. So what you have is an analysis of the pre-Enclosure Act ownership, and in that context, the interpretation of the Enclosure Act and its purposes.
Yes. I mean, plainly in that context, it did extend to workable and valuable stones, rocks of one kind or another. And one sees from the very beginning that the action was one brought in Trover, alleging conversion of stones, flagstones, and other minerals. And of course, fossils just means anything, I suppose, dug out in this context.
In those days.
I mean, not in the way which nowadays a geologist would use the word.
No, in those days it meant something solid. But you've got an express finding. Beds of stone, which may be dug by winning or quarrying, are therefore properly minerals. There's no reference in that to its valuable. There's no reference to beds of valuable stone that may be sold, that are merchantable.
I mean, the very fact these proceedings were brought shows that we're dealing with
Yes.
actually merchantable quantities of valuable material.
Yes, but 2 points. First of all, it's not part of the ratio. The ratio is quite clear. It's you get the surface being allotted and everything else below it is reserved. And that's the purpose of the act. The second thing is there's no analysis of what types of stones these are. The only analysis is they can be got out by quarrying.
Forgive me for asking an irrelevant question, but I'm just curious. Do you know who the other members of the court were? We can see that 7 to 8, one of them was Baron Alderson, because he asked a question. But it's not clear to me who else was on the board.
I don't know. I'll see if I can find out.
Thank you. I mean, as I say, it doesn't matter.
It can be occasionally interesting.
I'm just curious.
Yes. I'll find out. I'll see if I can find out. Now, that analysis of how an Enclosure Act operates is then supported by Micklethwaite and Winter, which is at tab 29. And this is a different sort of situation, although still questioning whether or not the Lord of the Manor can go along, or their assigns can go along and take substances from under the ground. Because in this particular case, you have an Enclosure Act where there's no express reservation of the mines and minerals, but there are provisions for the working of the mines and minerals. You see in the head note, 3 lines down, halfway along, the coal and minerals and unopened stone quarries under the surface of the common also belong to the Lord as part of the freehold. He was entitled to work the mines. The Act did not recite the particular rights of the Lord, but enacted that certain allotments should be made to the commoners in lieu of their rights, and to him for his right as Lord, to and in the soil of the said common, and also to and for the damage he was sustained by being obliged to make satisfaction to the proprietor of the lands enclosed for digging for any coals or minerals. And it was also enacted that the Lord, if the Lord should enter upon any lands for the purpose of digging any coals or other minerals, he should make satisfaction to the proprietors for the lands damaged done. The Act contained no clause in express terms excepting the mines and minerals. Held by the Act by necessary implication reserved to the Lord his right to the mines and minerals under the land so enclosed, and that he was entitled to work and paying compensation to the owners of the surface for damage thereby done. Held also that stones dug from quarries are minerals. Now, if you turn over the page to page 702, actually, that's... Hang on for a second. Actually, 703. 703, you've got at the top another reservation of seniorities with the same full, ample and beneficial manner type proviso. And then, second paragraph down, that if the Lord of the said manor, and this is the working powers, thereof should enter upon any lands or grounds to be divided or allotted for the digging, getting, and taking away, as they should respectively make satisfaction with respect to proprietor or proprieties of his or their tenant or tenants for any damage that he or they should or might thereby sustain. So you've got an argument, effectively, in this case, that the powers of working, without any sort of full, ample and beneficial manner proviso in that context, the powers of working implied that there was a reservation of the mines and minerals. Now, whether or not that implication would be found today, another matter, quite possibly, but that's not what we're going for. If you turn on to page 705, you get the judgments of, first of all, Chief Baron Pollock, then Baron Alderson, and then Barons Platt and Martin. And it's really for the purpose of identifying, again, how Wayman and Ross should be seen as a binding authority and how enclosure acts operate. So, Chief Baron Pollock, the plaintiff is entitled to judgment. I consider this case substantially decided by that of the Earl of Ross and Wayman. It's true that there were strong expressions there used, and the right of the law to mines and minerals more clearly defined in the present instance. There was a provision in that act that lords should have the right of taking. But though that is not expressed in this case, it is by necessary implication conveyed. Third section requires a allotment to be made for lord, not only as compensation for his right as lord to and in the soil, but also for damage he was sustained by being obliged to make satisfaction to proprietors for digging coals and minerals. I agree with Mr. Cowling, the 19th clause doesn't throw much light on it. Any argument used would be satisfactorily answered by the case of Town and Gibson. But the 20th section seems to me, by necessary implication, to reserve to the lord his right to the coal and minerals. And that's the powers of working I just took.
Yes.
The lordship too.
Yep.
It is found by the case that the Lord had the right at the time statute passed, and it does not profess to take away his rights except by the third section, which empowers the commissioners to divide the ways. The question is, what is the effect of that section of the Act? It's contended the effect is to reserve the Lord, instead of his right to the minerals, the incorporeal right to dig and take them, but leaving the ownership in the allotees. That appears to me a very inconvenient kind of right. And the more natural and reasonable construction is that the Lord being in possession of minerals, the Act intended his right to continue, and that if the exercise of it, injury was done to the service, he should make compensation. The Earl of Ross against Wayman distinctly decided the word minerals includes stones. Reference has been made to a Passion Yearbook. In my opinion, the interpretation given by my brother Alderson is the correct one. Looking at the whole of the Act, its intention clearly was to take the soil from the Lord and give it to the commoners, reserving to the Lord his right to the minerals, he making compensation to the allotees for damage done to the surface in digging for them. And that's, again, the purpose of these acts. Give them the soil, surface, and keep the minerals, including stone, in the hands of the Lord of the Manor. And then Baron Alderson concurs. The case finds that sometime in the passing act, the Lord was entitled to all the minerals and stones, so the entire soil belonged to him, and is further found that he had a right to dig for and take the minerals and stones, and that he exercised that right. Then comes an act enclosing the common, which gives the Lord compensation for his right to the soil and for the damage he would sustain by reason of it. Then to make the future satisfaction to proprietors of the enclosed land for injury he may do to and take the minerals. Then surely, when we find that coupled with a particular clause requiring him to make compensation, as we have, there is a general clause reserving to him his rights as Lord of the Manor. It is not an unreasonable construction of the Act to say that by necessary implication there is an exception to those minerals which the Lord had a right to in future to take from the enclosed land, and for the taking of which he is to make compensation, exactly as we have in our case. What here necessarily implied was stated in express terms in the Earl of Ross and Wayman, indeed in our case. The exception must be read according to the clause requiring compensation. Thus, the words meaning any coal or other minerals. The exception must be of all coal or minerals to which the Lord was entitled, and stone is one of them. Now, in our case, the Lord was entitled to anything under the surface of the common. There is nothing in the Act to take away the right of the Lord to the mines and minerals, but is qualified only by his being obliged to make compensation for the arties. And then Platt again says, same opinion, what the Act of Parliament passed. This common was the freehold Lord subject.
Yes, so we can read that.
Yeah, the one thing I would highlight is 4 lines down. That being the state of things, the Act passed, the object of which was to give in several certain portions of the surface for the use of the respective commoners. And then you get another one at Baron Martin at the bottom.
Perhaps I'm just being stupid. I'm just puzzled by the last sentence of Baron Martin's judgment. It says such stone is not included in the exception. I thought the whole point was it was included in the exception.
Yeah, and then he finishes up, but belongs to the Lord. I think he must be, must
not expressly included. Is that what he means? Perhaps. Anyway,
possibly, or possibly he meant such stone is not included in the conveyance. But he clearly says, but belongs to the Lord.
Yeah. Well, yes, that I do see. Okay. Okay.
So with that in mind, turning back to the Arusli 1816 Act at tab 24. At the first page of it, you have the preamble, which identifies, talks about where the first 4 lines talks about the manor, and then at the end of the fourth line, and whereas Sir Watkin Williams-Wynn, Baronet, is Lord of the Manor of Arusli aforesaid, and as such is or claims to be entitled to the soil of the said commons and wastelands. So again, exactly the same context as Ross and Wayman puts the interpretation of this act. And then over the page, at page 730, talks about the first part of that. It talks about it mentions the consolidation, the Enclosures Consolidation Act, which is at tab 20 for your reference, and talks about 4 lines down, and whereas I say commons and wastes are of very little value in their present state, and be very great benefit to the several persons interested in them. And the said commons and wastes, except such parts thereof as a situation in a particular parish, if their respective rights were ascertained, and the same were divided and allotted unto and among them respectively in manner hereinafter mentioned, but the same cannot be erected without aid or authority. And then it goes on. If you go down so it talks about appointing the William Pugh, Francis Bailey, and Frederick Rowe, and their successors be elected in manner hereinafter mentioned, shall be, and they are hereby appointed as commissioners as well, for the purpose of ascertaining the boundaries, as also for dividing, allotting, enclosing, etc., except such part thereof as a situation of Langaried in the said manner, and for all other purposes of this Act, and for duly putting and carrying the same into execution, subject to such provisions and directions as are hereby contained, and also subject to the rules, regulations, conditions, and directions of the said recited Act. That's the Enclosure Clauses Act, except so far and in such parts as are varied or altered by or repugnant to any of the clauses, provisions, or regulations of this Act. So what it's saying is, if you get your standard terms generally out of the Consolidating Enclosures Act 1801, except so far as they're varied or altered or repugnant to any of the clauses, provisions, or regulations of this Act. So, save as set out herein.
Sorry, could you just tell me again where this bit about repugnant?
Okay, 1, 2, 3, 4.
Which we in clause?
8 lines up from the bottom, page 730. 8 lines up from the bottom of the first paragraph.
Oh, sorry, the first paragraph. Yes, I was looking at the second one.
Sorry,
yes,
first
sorry,
paragraph.
no,
And directions of the said recited Act.
Thank you.
So whilst undoubtedly an allotment under this Act will be in satisfaction of, in lieu of, such rights as the Lord of the Manor has, that only operates insofar as it is not limited by the terms of this Act. So the reservation in clause 67 excludes that impact, or excludes that whatever is reserved under clause 67 is excluded from being removed by the Consolidation Act. And of course that has to work, because what's being allotted is in compensation or in lieu of what is being taken away. But if, say, you have a plot that's excluded from the allotment, that's not being allotted, so your rights under it are preserved. Slightly roundabout way of saying, if it's not being given away, it's kept. Now, Last two authorities I want to show your lordships on this are in bundle 1 of the authorities bundle. The first one is Concit. Concit Industrial and Province Society Limited against Concit Iron Company Limited. There are a number of... this is a somewhat peculiar report, because the main report, which starts at page 135 of the two Chancery reports, 1922, the main report is about Concit Industrial and Province Society Limited against Concit Iron Company, but it's decided on the basis of an earlier Concit case, which is reported as a note at page 187 of that, of those reports. And two things particularly come out of this particular case. First of all, if you turn to page 188 of the audit, and you go down to the third paragraph from the bottom, starting, "Now these enclosure acts are not like a contract, which may be casually made between individuals. They're unlike any other contract which has been made by anybody else. Enclosure acts are a common form which has existed for years. Whenever you have such a common form as that, where there may have been decisions as to the mode of construing those acts, it is not true in my view to say that the mode of construing them, which has been adopted by a court, is not to be noticed by subsequent courts. When you have two casual agreements, one of which may never be repeated, the decision about the construction of it cannot give any help in construing another one which is different. But when you have documents which are ordinary documents, they're not exactly alike, then the mode of construing them or any other construction, although it is sometimes somewhat objected to, is a word I very much like. Any canon of construction applied to the species of document, which is a common one. It seems to me the courts should be doing wrong if after a canon of construction has been laid down with regard to such documents, it should not be followed. So you've got it specifically saying enclosure acts are all of a type, you should be construing them together, and you have very similar words in the Wayman and Ross case to our particular reservation. The other point is that in this particular case, and this was very peculiar, what the main question was about how the mines and minerals could be executed. And you get this extraordinary situation where the Bishop of Durham, because they were so powerful, ended up with powers to work them. And if you turn back to page 139, you get the reservations, and basically the second paragraph starts with sections 45, 48 and 49, and the first part is seniorities and the like. So about halfway down the page, Lord Bishop of Durham and successors and assigns shall and may from time to time hold and enjoy all courts, perquisites, profits, blah 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 blah, down to the second hole punch. Other than and except such common right as could or might be claimed by him or them as owner or owners of the soil and inheritance of the said mortal commons, in as full, ample and beneficial a manner, to all intents and purposes, as he or they could or might have held or enjoyed the same as if this action had been made. And then you get the reservation of minerals, and also the said Lord Bishop of Durham and his successors, etc., may from time to time, at all times hereafter, have, hold, work and enjoy all mines, minerals and quarries of what nature or kind soever, lying or being within, blah, blah, blah. Now, over the next page, you get lots and lots of provisions about powers of working and so on. And then all the way through to page 141, talking about where it's just finishing off the powers of working, 4 lines up from the bottom of the first paragraph, or as aforesaid, as fully and freely as he or they might or could have had, held, used and enjoyed the same in case this act had not been made, and that without paying any damages or making any satisfaction for doing so. And this is the bit which I mentioned earlier. Section 48 then goes on to say, yes, you can get compensation, but what you do is not go to the Lord Bishop of Durham, but about halfway down, line starting any damage or making any satisfaction for so doing. For remedy whereof it be enacted, that when and so often as any person or persons shall suffer or sustain such loss or damage in his or her allotments or so on, and then jump down to the bottom, 5 lines from the bottom, starting assigns as aforesaid. Such person or persons so damnified, upon making such complaint, effectively they make a complaint to the court, shall receive such satisfaction for such damage as hereinafter is directed in that behalf. And then it provides the justices of the peace, shall hold the lands allotted to them upon trust to demise the lands for any term not exceeding 21, nominate a steward and clerk, after deducting salary of those officials and necessary charges and expenses attending the execution trust from and out of the net or clear rents. The residue or clear balance thereof shall from time to time be paid, applied and disposed of in a manner following. That is, they're saying that, again, the Bishop of Durham doesn't pay for it, there are some specific allotments to pay for damages. And that, we say, explains why you have in Ross and Wynne-Wynn this provision that you're supposed to keep the surface separate. And the reason for doing that is that the damages are going to be paid by all of the allottees rather than the Lord of the Manor. So there's a good reason for bringing about or forcing the Lord of the Manor in working the minerals to at least minimise damage. In our case, the damages are paid by the Lord of the Manor. The compensation is paid by the Lord of the Manor. I'm then going to, and that compensation provision effectively ensures that it's a wide interpretation that can be applied to the mines and minerals reserved. And you can see this at page 192 of the judgment. Last paragraph talking about when the legislature gives compensation in respect of all that's done, and it's talking about how much compensation should be paid. And if you turn over, no, not quite.
Sorry, I think you said 192.
Sorry, 192. Bottom of 192. 4 lines up from the bottom.
192.
Still concert. Tab 11.
Yeah. Oh, sorry, I've got it now. Yes.
This is now in the note of the other case.
This is in the note of the other
The
case.
Court of Appeal. Yes.
Yes. And the case was really about whether or not you could let down the surface. And then it talks about when the legislature gives compensation in respect of all that has been done. It seems to me the legislature meant to be full compensation. 4 lines up from the bottom, that is full compensation. In this case, therefore, you have the words very strong indeed, almost strong enough to carry the matter without there being compensation, but certainly absolutely strong enough to carry it if you are to give them their natural interpretation. And the cases seem to me to show that where there is compensation given, you are to construe the large words which precede that compensation and which give powers to the original owner of the land, if that is compensation given in respect of what he is to do in their ordinary sense. That seems to be the result of the judgment of the House of Lords in Love and Bell. The moment the fetter is taken away, which is put upon the construction by reason of there being an absence of compensation, and there is compensation, you must go back and construe the words according to their ordinary and therefore their large signification. And that will oblige us to say the bishop here reserved to himself, as I said, almost to be naturally expected he would, considering his circumstances and those of the commoners at the time at which this act was passed, unlimited power of working his minds as he thought right. So that's why, again, with our particular provisions, it should be interpreted widely. And then finally, just to nail this magic words argument, if you turn on to page 194, you get third paragraph starting the Enclosure Act. There was Durham Enclosure Act. Halfway down that paragraph, and whereas before that Enclosure Act the Lords of the Manors might have worked out all the minerals and let down the whole surface without making compensation to anybody, provided only they left common enough for the commoners, so it was argued that the Lords of the Manor had the right to work the minerals as against the allottees and let the land down without making any compensation because of the words in the Enclosure Act, in as ample a manner, and so on as before. So in as ample a manner is talking about how they work the minerals. And then it goes on, it was pointed out in answer that you cannot construe the words in as ample a manner in an Enclosure Act of that kind perfectly literally. Before the Act, the Lord of the Manor lets down the surface and makes no compensation. Why? because nobody's injured, but the moment you come to allot the surface and he lets down the surface, someone is injured. That was the whole controversy. Is he then to make compensation for the allottees who are injured, or is he relieved from the liability of damage, and so on? So what it's talking about when I say in as ample a manner or beneficially is how you exercise those rights. And that's finally put clear, if any other thing was needed, at 195. Just at the end of the marked passage, line starting was thinking about what it was about. Goes on, if we look at those two clauses, sections 45 and 48, which are the governing clauses, there will be found an enumeration of rights conferred upon the laws of the manor. I say conferred, preserved if you like, but they are nothing but general words. They're divisible into 5 groups, passing over the reservation of the right to the lords of royalties, which is immaterial. We first come to a group of words which relate to the working of the mines and quarries. It's enacted by section 45, the Bishop of Durham, his successors and so on, shall and may from time to time and at all times hereafter have, hold, work and enjoy all mines, minerals and quarries, what nature or kind soever, lying within the same or under the said laws to be enclosed. That's a grant to him of the mines and minerals. The words to have and to hold are ample for the purpose. So in our case, we have provision that nothing shall prejudice, lessen or defeat any right, title or interest which the laws of the manor now have or hath in any mines, ores, coals, metals, or minerals whatsoever. And that's the reservation taking place. And the fact there isn't any in as ample or beneficial means or the like does not make a difference. So once you have that in mind, you then look at what was being allotted and what was being reserved. And we've already seen the terms of the reservation. But I'm going to take your lordships briefly to one last point within the Arusli Act before going on to a slight analysis of why this is significant. So turning back to Authorities Bundle 24, Bundle 2, tab 24. So tab 24, page 744, and it's clauses 39 and 40. And this is what's allotted to the Lord of the Manor. So, and it be further enacted, the said commissioners shall allot and set out to the Lord of the said Manor of Rusty so much or such parts of commons and wastes within the parishes of blah blah and the townships of blah blah blah, which the freeholders have occupied in common with the above parishes and townships, as the said commissioners shall consider equal in value to 1/14th part thereof, and the said commissioners for the said parishes and townships mentioned shall allot and set out to the Lord of the Manor of such part of parts of said commons and wastelands of the same parishes and townships as the freeholders have occupied and enjoy, with freeholder having turned his sheep and cattle upon any particular part or portion thereof, but the boundary of which such part or portion has never been established or accurately ascertained, as the said commoners shall consider an equal in value to 1/20th part of the last mentioned commons and wastelands. And then there's further provision at clause 40, where it's provisions for various townships, as they shall consider an equal to value of 1/14th part thereof. So what you're getting is significantly small allotments. And if you turn to tab 33, you get an extract from the enclosure maps of England and Wales. Tab 33, turn over the page to page 7. And it's the marked up section. Need to preserve or confirm. In fact, if your lordships can just read that, but note that the important point being, if you've got full allocation of land and you're not reserving
Sorry, can you just give us a bit of context? You've shown us the title page of the publication. which describes it as an electronic catalogue and database, I'm assuming this is some kind of introductory essay to the catalogue by someone.
I think that must be right. Can I just take one moment? Yes, it is.
My lord, it isn't. In fact, it's my book. I'll bring the book over this afternoon.
Well, there you go.
Thank you, Mr. Arnold.
So the point that I would like your lordships to take away from this is that, in general, Lords of the Manor had to make a judgment whether to take their full allocation of land, normally 1/7, and lose any rights to minerals which they might be found subsequently, or to take a smaller amount, usually 1/16, or retain their rights to anything which might be exploited in the future.
Well, I mean, all of this is very interesting, this historical background, but how is it really going to help us on working out what it is that was a reserve?
Well, we say, number one, it's clear that the minerals were reserved. The only question is what...
Absolutely,
Okay.
yes.
Number two, it's Ross and Wayneman and Micklethwaite and Winter explain that in that sort of clause, in that sort of position where you are identifying surface versus being allotted and retention of the mineral rights, you are retaining everything under the surface, including stone that can be quarried. And whilst, yes, the actions are brought for valuable stone, because that was what was being taken, it's not a requirement. It's everything that was under there. And the reason that it's not a requirement is that if you were the Lord of the Manor, underneath the commons and wastes, you could take whatever was there, because you owned it subject to rights of common and so on.
I may be being a bit dense, but why is this not this argument about the economics against you? Because take the example which is discussed in the passage in the essay to which you just refer as County Durham. Well, I mean, we all know what's going on there. It's coal. It was, even at that time, it was a major coal mining area. And coal was recognised as an economically valuable resource. And of course, that is an important part of the context. We can all understand that. But why does that assist you? Because we are here concerned with something that was not appreciated as being an economic resource at the relevant time.
The reason is this. Either the Lord of the Manor is saying, I will take 1/7 allotment, and I'll give up all of the land, including what's ever under the surface. Or they're deciding that they're going to take a smaller allotment, but retain whatever rights they had to the subsurface. The fact that they were either unaware of any particularly valuable mineral rights, or they thought there might be in the future, really just amounts to what sort of bargain they were making. And you can see that it's going to be differing percentages or differing fractions depending on the particular locality. But the smaller the fraction, the more they must have been reserving elsewhere. And it's going to vary from place to place what the non-mineral rights are worth. And there will be in some situations where the mineral rights were valueless or not considered to be by anybody to have any particular value. But the primary point is this. When you're looking at an Enclosure Act, if you've got those smaller fractions, 14th, 16th, 18th, 20th, it is a good indicia that there has been a retention of the mineral rights of the Lord of the Manor. And it's not about whether or not the Lord of the Manor has valuable mineral rights. It's about the Lord of the Manor's rights as Lord of the Manor to everything under the surface before enclosure on the wastes and common land. if you were dealing with the Bishop of Durham with coal mining and so on, you have a particular set of circumstances because the Bishop of Durham is so powerful, he's going to bargain hard. That's incidentally some of the comments made in concert, which may affect the particular fraction that they get. It may also be that somebody looks at it and says, you know, those mineral rights are particularly valuable, therefore you get a smaller fraction if you're retaining them. But it still indicates, we say, that if you've got a 14th and a 20th fraction here, that they are retaining mineral rights. But again, it is the way that this is retained is not by saying, I will retain copper, or I will retain this. It's retaining, by the very nature of an Enclosure Act, whatever is below the surface, because that's what the Enclosure Act were doing. They were allotting off the surface and keeping everything below it.
Well, if that was the sole purpose, it could have been expressed in one sentence, couldn't it? Everything beneath the surface is reserved, Lord of the Manor.
The
That
way
would have
they
saved
did it was,
that would have saved an awful lot of space and trouble.
it could have been. They could have done it that way, but they did it in this particular way, and they did it repeatedly in this particular way because it was what happened to be in certain circumstances. What the Lord of the Manor was entitled to might vary potentially from manor to manor, depending on the customs and so on. But here, and Russell Wayman has made this quite clear, it's everything including stone that could be dug from quarries.
Is it everything including stone which can be dug, or everything including stone which is worth bothering to dig?
Everything that's stone that can be dug, and I'll take you back to Ross and Wayman for those precise words. Yeah, page 730, tab 27. The term minerals here used, they more frequently applied to substances containing metals in its proper sense includes...
I'm sorry, can you give me the reference?
Sorry, tab 27, page 730. My apologies.
Sorry, where are you?
730,
Yes.
first full paragraph starting the term minerals.
Yeah.
The term minerals here used, they more frequently applied to substances containing metals in its proper sense, includes all fossil bodies or matters dug out of mines. And Dr. Johnson says all metals are minerals, but all minerals are not metals. And mines, according to Jacob's Law Dictionary, are quarries or places where anything is digged. Minera de period de charbon is spoken of. Beds of stone, which may be dug by winning or quarrying, are therefore properly minerals. And so we think that must be held to be the clause in question, bearing in mind that the object of the Act was to give the surface for cultivation to the commoners, and to leave in the Lord which it did not take away for that purpose. So it's not valuable, it's just stone. And it's not by reference to value, because it's about the tenants get the surface, and that's all.
Well, they get what they need for cultivation, which implies some depth, but I suppose your answer to that is the same, that you're relying upon the bedrock.
Yes.
And not anything above the bedrock.
Yes. Yes, there is. I accept there is that ambiguity in that particular passage, but yes. And it's why Enclosure Acts should be interpreted differently from standard contracts. It's about what they were trying to do. And it may seem peculiar today, but 200 years ago, the yeoman farmer would have seen this as a perfectly ordinary action.
What puzzles me at the moment, Mr. Moran, is I don't quite understand why the logic you're advancing distinguishes between the two things we're trying to distinguish in this case. Which is, does it mean stone worth quarrying, or does it mean every conceivable piece of bedrock? I just don't understand how the argument bears on that distinction, because it's always talking about stone worth quarrying.
It's not talking about stone worth quarrying. It's stone that may be dug by whinnying or quarrying.
Right? And who's going to do that if it's not worth doing?
Well, whether or not they do it, it's still part of what can be extracted. And it's being, in this particular case, it's proved the fact that people do dig it out,
Right.
even if they're not going to sell it.
Right.
So, in a sense, this is clearly stone that's worth quarrying because it has been quarried.
But this comes back to the economic analysis, doesn't it? Because if you need a building material for your road or even for your house, and there is nothing else available, then you will take the mudstone. Doesn't mean to say that it has any economic value in the market.
Yep.
And the question, therefore, is what is being referred to here something which has economic value in the market, or does it extend to a material which is convenient because it is to hand in the locality? And hence the interest in cultivation. Because, of course, if you're talking about subsistence farming, then the question of what is to hand in the locality for building your road or your track or your store or hayloft, whatever it may be, is of some significance.
First of all, yes, if you're talking about subsistence farming in, for example, North Wales in 1816. But secondly, this is not, one can't look at enclosure acts through a standard commercial conveyancing lens. Because it's not about what people are buying or selling. It's about dividing up the land. And the question then becomes, what is being allotted out? And if what is being allotted out is just the surface, then the reservation makes much more sense if the reservation includes all the stone, irrespective of its particular economic value. And that's why enclosure acts don't get to the exceptionality or profitability or value tests. Because it is not about how people will be trading, buying or selling standard land. It's about division of the land into cultivatable, enclosed plots. And
well, you're undoubtedly correct to say it's not a standard arm's length commercial transaction. On the contrary, it's taking the commons and privatising. But it's still all driven by economics, because the whole point was that, as we would now express it, although it wasn't quite expressed in these terms then, that it was thought that privatisation would be economically beneficial.
yes, but it was privatisation of the surface, prima facie. Certainly with these proportions being allotted to the Lord of the Manor.
I mean, again, the bit of this I don't follow at the moment is that you said it's not like buying and selling and everything else, but isn't your point about the difference in the allotment the Lord of the Manor gets, depending on whether they get the minerals, precisely an economic exchange?
Well, yeah, but yes, there is an economic exchange, obviously, but it's not about a standard, I buy this plot of land. It's about enclosing the surface. It's about that. And that's precisely what Ross and Wynne-Finch,
Yes,
what
but
Micklethwaite and Winter specifically say. It's about dividing up the surface. And if it's about dividing up the surface, then you don't need to think about the value or economic use of whether or not this is being reserved out of it. It's simply, you will take the surface and I will keep whatever is below it. I'm not giving it away.
But that's because it has an economic value.
Well, it's certainly got an economic potential value.
And that surely must be what explains the difference between the fractions. I mean,
Yes.
the lower the fraction, the less on an educated appraisal is there likely to be any form of economic potential under the surface.
Yes, but it's a simplified economic analysis. It's surface versus subsurface compared to all of it.
As I put to you 20 minutes ago, I mean, if the intention was that everything under the surface should be effectively reserved or re-granted, then it would have been ever so simple just to say so.
You're going to have the powers of the workings, and you're going to be describing it in terms of what the Lord of the Manor had already, as opposed to, and it's what the Lord of the Manor had. And
well, that rather begs the question, doesn't it? I mean, you have to construe what it is that is reserved, and then it is to be held and retained in the same form as previously. But, I mean,
yes,
but I don't think it helps you really identify the extent of the reservation.
No, but that's what Ross and Wayman tells us, and Micklethwaite and Winter tells us what the extent of the reservation is, and why the extent of the reservation is like that. So, it's longer drafting than you might use today, but it's how it was done then. It identified in a particular way. It is an enclosure act in materially substantially the same manner. It should be interpreted in this way because this is how it was done. Say the barons of the Exchequer Court at the time. My Lord Justice Arnold mentioned something about allotment, subsistence farming, and whether or not people would be using what was available and so on. There's one point which may assist your lordship on that. If you're still in Authorities Bundle 2, turn to tab 24, the Act, on page 748. Oh no, not 748. Sorry, there's a provision for setting aside an allotment for Turberry, which I've lost, which I will...
Section 37.
Ah, thank you very much. I'm grateful for that. Section 37. Ah, yes, Private Turberry, page 744.
Forgive my ignorance, what's Turberry?
Turberry's the right to draw turf for burning.
Oh, of course, right.
And what happens at Section 37 is allotment for public Turberry, etc. Be it further enacted, the said commission shall set out and allot such part or portion of said commons or waste in every parish in such place or place that is judged most convenient, be used and enjoyed forever after by the respective proprietors of lands and hereditaments within such parish as public Turberries, and ultimately award the same by virtue of this act in common for the people of getting heath or peat for fuel only, building stone, gravel and sand for the use and benefit of such houses, buildings, lands, or regiments situated in such parish, and of such erections as shall be made thereon, and also for the repairs of the highways, private roads, and paths within the same, provided always that such heath or peat, stone, gravel, and sand, or any part thereof, shall not directly or indirectly be sold or disposed of to any person or persons. So it's saying we're keeping up some particular points for making sure that everybody, not just, to be fair, not just the copyholders, not just the allottees, but also the members of the parish get an opportunity to get these things to maintain roads and build houses, etc., etc.
These enclosure acts were presumably normally promoted by the Lord of the Manor, or
pretty much.
Right.
I'm sure that occasionally it was more widespread, but certainly the Lords of the Manor were amongst the primary movers.
And I probably goes without saying that at that date there was no provision for Parliament to take account expressly of the interests of the people who actually worked the land, as opposed to those who were in receipt of the rents and profits in one way or another.
Well, no, because if you work the land as a copyholder, under rights of common, then you would get allotted some of the land as appropriate to your rights.
But these copyholders, I mean, are we thinking of lots and lots of very small holders, or are we just thinking of other absentee landlords?
There was a mixture, but lots and lots of small holders were there. and you ended up with a patchwork of fields that now dominates England and large parts of Wales. It did exactly that. The problem was for some people they didn't have any rights which were converted, and there were a few people who ended up with nothing at all as these things happen. You didn't get enclosure acts in Scotland. You had the clearances instead.
Yes.
I have to say, on this one, Mr. Wonnacott is more of the expert and historian, but broadly speaking, yes, the small people got small pots, and the Lord of the Manor got large pots.
I expect if one delves, there's an awful lot of, to modernise, very unpalatable exploitation of the very poor going on. But
probably.
with not much thought for their interests, quite frankly.
Certainly, there were people who were going to be a lot worse off. It did radically alter agriculture in Britain for the better.
Well, in some protests at the time.
Yes.
Indeed. Yeah.
Yes.
Yes. And in a sense, that's all rather double-edged, but I suppose if you're being very hard-headed, you might say it encourages a rather sort of hard-nosed approach to what it is that's being reserved. One should treat it as sort of probable that the Lord of the Manor would have wished to get away with everything he possibly could.
Yes, and actually, can I take you back to Authorities Bundle 1? Tab 11, it's the concert case. And it's page 188. It's just a little passage that does put exactly your lordship's point into context. Tab 11, page 188. It's talking about, or in fact it starts at 187, it's talking about the Bishop of Durham as Lord of the Manor and owner of the manor, subject only to a right of common on the part of certain commoners, and at that time, therefore, the bishop's rights, 6 not to none, were with regard to the mines absolute. And it goes at first full paragraph at 188. Under those circumstances, the Bishop of Durham of those days being one of the most powerful landowners and one of the most powerful persons in England, it was proposed that there should be an enclosure, and an enclosure act was the result of agreement or agreements between the parties. Therefore, with the immense power of the bishop, and with the then really known value of the mines under County Durham, more particularly in such a place as under such common land as this was, one would be prepared to find the bishop, with regard to the minerals, would reserve the greatest possible power, that he would be very little inclined to give up any power with regard to the minerals that he had before. In other words, he would be inclined to reserve to himself the right of working the minerals as he thought right and without reference to consequences to anything on the surface. One would be, I think, prepared for that. Now, in North Wales, Sir Williams-Wynn, Baronet, owning thousands of acres as one of the major landowners in North Wales, maybe not as powerful as the Lord Bishop of Durham, as the Prince Bishop of Durham is, but in a similar to equivalent position, it's going to be keeping as much as he possibly can. And whether or not there is an identifiable value at the time in 1816, there may not be coal, but there may be. There may not be gold, but there may be. You look to the future and think anything that's in there, maybe it's useful. I don't know what's going to be useful in the future. I'll hang on to it. It's one of those decisions that you take as an estate owner for the long-term possible benefit of your grandchildren.
Well, I quite understand that argument if one's thinking about what we would think of as valuable minerals of one kind or another, or indeed the potential of some valuable mineral turning up, who knows, half a mile deep in the way nobody had at the time contemplated or have been able to prospect for. But the present case is all about just the local mudstone, which is a very different matter. I mean, that's what is there for everyone to look at and walk over and pick up stones and use for whatever purpose.
Which turns out to be valuable. Now.
Well, yes, but valuable in a very different kind of way. I mean, it's valuable in the sense that, use any bit of the ground, one way or another, can be turned to use if one's really, if push comes to shove and you have no alternative. Yes. But I mean, that's a very different concept from economic exploitation on terms which a landowner would normally objectively think of as sort of worth driving a hard bargain for.
Not necessarily. I mean, if you think about this in terms of the great landed families, the great settled land, the great estates, they are looking at maintaining value for generations.
I accept that.
And what may be trash today may be valuable tomorrow. Ransom strips may in and of themselves be worthless, but later they may have extreme high value. you don't know what's going to be valuable 200 years in the future. You don't know what people are going to be doing with land 200, 300, 400 years in the future. As it turns out, this has got an economic value. This has got the possibility of negotiating value, not just for the roads, but for, if there are wind farms built, there's going to be an enormous amount of this material extracted and so on. And yes, it's at the time you're sitting there thinking, well, it's not very valuable today, but I don't know what it's going to be like in the future. And that's why, if you're a long-term assessor, you think, well, admittedly, it's a long-term gamble, but it is an economic assessment. I'm retaining all of that material. I'll take a smaller allotment, I'll retain all of that material, and see what can be done with it in the future. And it's not, whilst obviously, if you can identify today certain valuable materials, that's clearly an indication that that's going to be more interesting for attention. That's not the be-all and end-all of it. And the fact that it's useful and expensive and valuable at some point in the future in a different way can be taken into account if you're long-term enough.
So, but your reference to a ransom strip is interesting, because isn't that precisely the argument against it? The whole point is that ransom strips have no inherent value in themselves, except that they enable the landowner to extract a ransom from a neighbouring piece of land. And the argument against you is that in a rather different context, essentially what you're trying to do with the mudstone here. It has no intrinsic value. It's just that if there's a legal right, then a ransom can be extracted using it.
We do say it does have inherent value. It's just inherent value to this particular person in this particular context. It's not a ransom strip in the sense of we're going to stop you doing something. They can do it with somebody with stone elsewhere. It's cheaper to buy our stone. But even if one does use a ransom strip, that's not against me. That's exactly what you want to retain. If you can extract value by means of ransoming, that's something of otherwise not valuable material. That is something that a lord of the manor looking at this may be considering in terms of value into the future. There was a lord of the manor a few years ago who extracted £100,000 from the local council for building a bridge across a river. I mean, it's a totally worthless right, except for the fact that the council wants to build a bridge across a river. But they retained it, they reserved it, and now they got it. And also, when looking at manors, they are of that peculiar nature. You get an agglomeration of different rights that can be used in peculiar situations. I mean, a right to a deer dam, that's an object that happens to have killed a person and is sacrificed thereafter. That's not really a valuable right in any normal circumstances, but it's still reserved just in case something happens later.
These aren't being reserved as ransoms. I mean, I understand the point, I completely understand the rationale of saying, well, lords of the manor would reserve ransom strips or ransom anything. But that's not your case. Your case isn't that the rights that you're claiming were reserved as some kind of ransom.
No.
You're saying they weren't. They were reserved as whatever they are, mineral rights, and you say that includes stone, and you say it includes the bedrock.
Yes, but I'm explaining that in terms of it may not be, the fact that it didn't have any particular identifiable value at any one particular time. Say in 1860 they looked at it as not particularly valuable building stone, it's still there. Doesn't mean that it's not of value to a lord of the manor who's looking at it. I'm not saying that these were reserved as ransom items. I'm saying that why you would want to reserve generally includes a whole host of different reasons, including whether or not it's particularly valuable, but not limited to that. And that's why, when you look at what it includes within the reservation, whilst obviously, said it was coal, it's fine, that's going to be pretty clearly reserved, but it doesn't limit it to just valuable materials at that time, because there is more to it than the value of the material per se today when analysing the actions of the person reserving it.
I understand, but the point that's put against you essentially comes, at least in my mind, comes down to this, that what was being reserved was anything worth taking out of the bedrock. And what you're now trying to say is that that actually included the bedrock, even though it wasn't worth taking and isn't worth taking. And that's what this case comes down to. And the bedrock would be a ransom. To say I'm going to own the bedrock, because that's a way of ransoming all mineral rights of any sort because I own the bedrock, which means you can't get them because you've got to go through my ransom bedrock. But that's just the opposite of what this case is about.
The ransom has set a hair running. That's just an example of when things aren't inherently valuable themselves, they can generate value. This is not a ransom strip. This is, it's clearly not a ransom street, it's not being exercised or
But
reserved as such.
isn't your point about suddenly saying, oh yes, well actually the mudstone has a value, is that such a change in your case, isn't it? Because I don't mean you didn't say that below, but in terms of construction, because the argument in this case is about whether these provisions mean you can have everything that you can take out of the bedrock. But now you're saying actually the mudstone is something good you can take out of the bedrock, but the problem you've got is the mudstone is the bedrock.
No, we're saying that you get the bedrock, which is the mudstone. That's what you reserve, not things that you can take out of it. Just the bedrock mudstone.
No, sorry, forgive me. I understand that that's your case. You say you get everything, but when you start emphasising its value, which is what you were doing a minute ago, then that seems to me to be making precisely the opposite point, because now you're saying actually stone doesn't include that.
No. I was using that to explain why one of the reasons the law of the manor is going to reserve everything, not just the currently valuable things in 1816. But the reason that the reservation goes that far is it is a simple operation of surface versus subsurface. Mm-hmm. And it's not the valuable things that can come out of stone. It is expressly, in Ross and Wynne-Wynn, stone that can be quarried.
Is it what Baron Martin thought Ross and Wynne-Wynn meant in Micklethwaite? What I'm talking about there, as I'm sure you're aware, is the bit in Baron Martin's short judgment where he distinguishes between stones and other stone. That's at 706 of Micklethwaite.
Yeah, I don't know about that because that's not what Ross and Wynne-Wynn says.
Well, it does. At least as I read, let me tell you how I read Baron Martin. I appreciate he's not Wynne-Wynn, he's Micklethwaite. Mm. But as I read that sentence, or two sentences, he says the next question is whether stones are minerals within the exception. Earl of Ross and Wynne-Wynn is a direct authority that whatever stone is got from quarries and separated from other stone is minerals in the ordinary sense. In other words, he seems to be reading it as being, and I'm going to paraphrase it in a different way, stone worth taking out of the bedrock is stone, but not the bedrock, the other stone.
I think he's saying taken up from the bedrock.
Well, he's talking about separated from other stones, isn't he using the word stone in two senses, clearly as one worth taking out and one that's the other stone? Well, that's anyway. I'll tell you how I'm reading it. You can tell me.
I would say
your submission that
it's
that's not the right
taken
way
up
to read
from.
it.
I would say it's stone that's taken up from the stone,
Right.
separated from the bedrock.
Yes, in other words.
No.
I won't get into a dialogue with you.
You've got a 1 metre cube of bedrock.
Mm-hmm.
You dig your knife. I know your spade, whatever. However you do it, use a blade to cut off a chunk that has been separated from the remainder of the 1 metre cube. Mm-hmm. Bedrock's still there. That's your mineral.
Right.
But that's quarried out.
Mm-hmm.
It's not that only part of the stone in the bedrock is minerals. It's the bedrock is mineral.
Okay.
It's 7 minutes to 1. I've got the category C to deal with, and then of course the adverse possession. Category C will not be very long, but it does seem possibly a good time to stop for a short adjournment.
Well, I was going to say perhaps we might get on with category C just until 1 o'clock, because I just think there's quite a lot to get through in this case. So
yes,
you should have.
No,
indeed, you might be able to
finish it before lunch. You never know.
Depending on how short your points are on category C. But anyway, we're on to category C now. Is that right?
Category C.
And could you just remind me which of the plots we're concerned with? I know there's this confusion about whether it's 24 and 25, and I've now forgotten which.
They are what? C17 and C25.
25.
25.
Right. Thank you.
So this is a very discrete issue. Essentially, the question is, did the respondent's predecessors in title obtain, we say the question is, did the respondent's predecessors in title obtain a severed or unsevered, severed surface from the subsurface? Now, in most of the category C titles, our problem at first instance was that the conveyances were usually in a form like this. I, the vendor, will convey land X to be held by the purchaser beneficiary, subject to the law of the manor's rights to mines and minerals set out under a private enclosure agreement. And, first instance, it was held that that didn't sever, and because of Ashburn and Stubb, the land was not subject to those rights because you can't pass on the obligations of a private agreement. However, where the Lord of the Manor has got those private agreements in place, and then the occupier of the land passes on that land, and only passes on the land with an exception for the mines and minerals, then there is a severance. So if what happens is the conveyance is I, the vendor, convey land X, except for the mines and minerals, to be held by the purchaser beneficially, then the next occupier is only occupying the surface. Now, if the first person is occupying under an agreement where they don't occupy the Lord's mines and minerals, they don't get adverse possession. And if the subsequent purchasers only take a title of the surface, they don't get adverse possession because they're only occupying the surface. Now, this is subject, of course, to more general adverse possession. And in our case, there are these two plots where you have conveyances of land that was subject to private enclosure agreements that have that type of exception. And the first one is the plot C17, and that's, you can see the conveyance in question in the core bundle at tab 16H. This is a 1924 conveyance by Sir William-Wynn, actually. And it is, in fact, in terms very close to a Category A conveyance. You can see this at page 230. I will read out the relevant parts, and you see about 6 lines down it says, now this indenture witness that in consideration of £750, the trustees now paid by direction of the vendor, receipt whereof is acknowledged. The vendor is beneficial owner by virtue of powers under the trust to settle land acts. Then goes on, and of every other power, if any, enabling in this behalf, doth hereby convey unto the purchaser's heirs all that, moorland or sheep-hawk, etc., etc. And then you go down 8 lines, starting verge line, except and reserving to the vendor and his heirs and successors in the entitle under the said indenture of settlement and his or her and his and their signs all mines, beds, and quarries of coal and ironstone, and all other metals, stone, and minerals, etc., etc.
So we have the express reference to stone.
Got the express reference to stone.
Yeah.
You then, that's plot C17, and then plot C25, you have a 1931 conveyance, which is only referred to in we've only got evidence of it in the 1956 abstract of title, which is at tab 16J, page 243. And the abstract of title starts at page 244. You see on the left-hand side, 16th of March 1931, stamp £44. By conveyance of this date, Sir Charles Henry Stuart Vane, Tempest Stuart, Marquess of Londonderry. Thrinner Ed Vendor, one part, and then purchasers of another. And then it's witnessed as follows. Vendor as beneficial owner hereby confers all property. All property described in first schedule and delineated on plan thereto, annexed and then coloured pink, together with easements, rights and privileges mentioned in the second schedule thereto, but subject to exceptions and reservations in the third schedule thereto, to hold unto the purchasers. And then if you turn over the page, third schedule, the bottom of that, page 245. Third schedule, parts of exceptions and reservations. 1. All mines and minerals in or under the property are accepted from this conveyance and are reserved to the vendor or other persons now entitled thereto in fee simple, with full right and liberty for the vendor and such other persons as aforesaid. Now, that one is just a mines and minerals. But under private enclosure agreements, we were retaining the rights to all the subsurface. So the basic argument for this is either A, we're still entitled to the mines and minerals in its more limited form. B, since there was a severance of the mines and minerals, it's more difficult to see how there can be occupation of anything below the surface for the purposes of adverse possession. Which brings me neatly on to adverse possession, and it is 1 o'clock. But just before I deal with that, I'll just dot I's and cross T's. So the judge made her mistake at paragraph 133 of her judgment, where she said the agreements didn't set the title. We accept that. We're not appealing that decision. But what she failed to deal with is the fact that in this particular case, the conveyances did. What the agreements did was stop the original occupiers of the land obtaining title themselves by means of adverse possession. And then nobody else did, because they only took the severed surface title.
I'm sorry, this is entirely my fault. I'm just losing track of, as it were, the context in which this conveyance was made. The conveyance is by obviously a grandee, but not one of the Viscount, whatever. No, sorry, Marquess of Londonderry. I mean, but he's not a. How did he get it? How did he get this land to dispose of in the first instance?
That was.
I mean, is he one of the? He's not one of the Wynne family or anything.
No, but there was enclosure agreements with the Marquess of Londonderry.
So he.
Let me double check that.
Yeah, that's what I rather thought that was the case. But
yeah.
So I mean, so he's not exactly a. He's not a tenant farmer himself. Obviously, he's another grandee absentee landowner.
Yes, probably. But
so he gets his title as a result of one of these private agreements, which it's now called.
It was in fact an 1857 enclosure agreement between Sir William-Wynn and the Earl Vane, which is the subsidiary title. To the
yes, I see.
And then in 1931, the Marquess of Londonderry sells it on to somebody else, but subject to this reservation if whoever's entitled to the mines and minerals. And since he wasn't entitled to them, it was actually still us. There was a reservation of that.
You say it was still you. Is that because it's now common ground that these private agreements created no more than a contractual license? Or I got entirely the wrong end of the stick here.
I don't know if it's common ground, but that's what we say.
That's what you say.
Yeah. And because of the agreements, because they were permissive to allow them to occupy and enclose these private areas, and also because they were representative of where the sheep walks were, which was an exclusive right of common grazing. And because the sheepwalk holders, it's actually under a particular case which we haven't got a copy of in these authority bundles, because the sheepwalkers occupiers could not get adverse possession because they were doing so under a particular adverse possession of land because they were occupying it pursuant to their rights rather than adversely. And in particular, after the private agreements, because they were occupying pursuant to private agreement, the private agreement holders couldn't get adverse possession below. And if their success is entitled occupied pursuant to a severed surface title, they wouldn't get adverse possession of the subsurface.
I'm still not sure I've got my head around this. Is this spelled out in your skeleton argument somewhere? Well, can you perhaps think about that? And,
yes.
Because it's already just now well after 1 o'clock, so let's continue at 2 o'clock. If that's
2 o'clock.
all right. Thank you very much.
So, advice